Yes.
Well, can I try and deal then with the question that was raised in relation to whether the judge dealt with the Guardian's comment about the proposals for contact being me? And I'm afraid I'm going to try and put some context to that. My understanding is that the proposal that was being responded to at that time was a proposal for contact to be once a fortnight at the contact centre that my lord then refers to appears in the final order. It doesn't appear that the judge dealt with that specific proposal and any differences between the parties on contact in her judgment. I understand from my learned junior that there were requests for further clarification from the judge and on the 1st of November she responded, and one of the requests had been in relation to the issue of contact and what her proposal, what her position was on the contact issue. And on the 1st of November, I understand that she indicated she wouldn't deal with it in a response to request for clarification, but she would deal with it on the 4th of November. There's then in the supplementary bundle a court order of the 4th of November, which is at SB 276. I'm sorry, let me just try and get that up. But if memory serves me correctly, what she was doing was indicating that documents needed to be filed, setting out what the local authority position on contact would be. That led to the care plan of the 11th of November, which is in the core bundle at F172, at which point the contact proposal has moved from once a fortnight to once a week for the 2.5 hours, which is then what appears in the final order that you've already dealt with. My lord, what I don't know, and I'm sorry I didn't get a chance to clarify this with my learned friends, is whether that arrangement in the final order was then dealt with consensually or whether the judge had to make any determination in relation to it. If I may just briefly go back to a couple of the matters from before the luncheon adjournment. Again, my lord, just dealing with your point about whether the judge doubted the mother's sincerity. I don't think this is a paragraph in terms of this separation. I don't think this is a paragraph I've taken you to in her judgment yet. Paragraph 331 at E50. And again, it's less perhaps of doubting the mother's sincerity, but more consideration as to whether even if the mother was being sincere, the judge can have confidence in the mother's approach. So at 331, for all these reasons, I have very little confidence that the mother has truly embarked upon her journey of separation, and consider that the disentanglement of parents from one another must not only start in earnest, but be well established before Millie can be considered to be safe in the mother's care. So I don't think that was a paragraph I'd taken you to before. And then in response, if I may, just to the question that was raised, that's already probably helpfully been answered by my learned friend on behalf of the child, E69 in the judgment, and the consideration under paragraph 462 of welfare and 463 presumption in favour of children being placed in parental care. The case authority that you referred to, the REN authority, in particular paragraphs 58 to 62, included recitations of earlier cases which made it clear that there is no presumption when you are considering matters of welfare as opposed to threshold of favour of a parent over another carer or another family member, because the test at that stage is purely welfare of the child. However, what we say in relation to that is that nobody invited the court to approach the matter in an impermissible fashion, and the judge didn't approach it in an impermissible fashion, because we can see that that then is tempered by the approach under Article 8, which is referred to at the bottom of paragraph 463. And if you also look above in paragraph 462 little 4, what the judge does, having identified that there's no presumption in favour of her being brought up by a parent over any other relative is recognising a decision which involves long-term separation from her mother, her primary carer, with whom she has always lived, requires a high degree of justification. I must also be satisfied that there's no practical way that the local authority or others can provide the requisite assistance and support. So whilst it might sound surprising, there is good justification in the case authorities that it is welfare rather than a starting point that tips you into coming to a particular conclusion before balancing all of the factors you need to do to determine the best placement for the child. I think, having dealt with those, I have probably filled in as far as I'm able to on matters of questions that were asked earlier, save for as yet, my lord, we've not been able to trace the case from some time ago, but I will carry on endeavouring to do so whilst my learned friend is on his feet. If I may just once again turn my back. Is there anything I can assist you with?
Yes, I'll ask you the same question that I put to Mr. Nuvolone. If, and I stress if, the appeal is allowed, do you have any observations as to what form of order would be appropriate in those circumstances?
My lords, it's difficult to see how it would be appropriate or possible on the information that you have for this court to deal with it by way of substituting any other final order, and that it is most likely to have to return in those circumstances. Certainly at this stage, the local authority, if my lords were considering, for example, a care order but with some form of invitation for the child to remain at home, that would have to be something that would need to be considered back at the local authority through the proper procedures of the placement with parents. And so it's not an outcome that could be properly and permissibly achieved by the court endeavouring to impose that arrangement on a local authority at this stage. And so in those circumstances, I think probably the second of the options that my learned friend indicated, which was to replace, effectively to set aside the full care order, but to replace with an interim order. And then there can be further consideration in the court below as to the nature of any future hearing and any dispute that there is at that stage between the parties.
That's helpful, thank you.
Unless I can assist you any further.
No, thank you very much. Mr. Goodwin.
My lord, on behalf of the child, I propose only to make abbreviated submissions in support of this appeal. The Guardian is clear that the result below was the wrong outcome for the child. And I don't mean wrong simply in the sense that the Guardian disagrees with the order made by Her Honour Judge Bugeja. That, of course, is not the test on appeal, but we mean wrong in the sense that the judgment discloses fundamental errors. In that respect, adopting as I do the appellant submissions made today, we summarise our three key points in relation to the core deficiencies within the judgment as follows. 1, there was no sound basis on which the court could conclude that the mother was likely to expose the child to harm at the point in time when that risk would eventuate. 2, there was no proper analysis of the steps required to monitor the placement at home effectively and to apply local authority services to reduce the risk, nor an adequate analysis of what order would best meet the child's needs if she remained at home. And third, 3, albeit overlapping with those first two submissions, we submit that those errors undermined the judge's comparison of the placement options and therefore ultimately her proportionality evaluation in relation to removal. Before I develop any of those points, and as I say, I hope to only briefly, may I start with the question that your lordship has raised thus far of each counsel in relation to the steps that this court should take if the appeal were to succeed. I accept, of course, that if there is a remission, that would need to be done under an interim care order. Absent an interim care order, there would be no basis on which the court below could become re-engaged with the case. However, we push back, at least to a degree, against the suggestion that this court, if the appeal succeeds, has to make an interim order. And we invite this court to give serious consideration to achieving finality at the conclusion of this appellate process for two reasons. First of all, your lordships have a shadow care plan already predicated upon a care order being made with the child at home, and that sits alongside a supervision order support plan. So the evidence is already before this court as to the services and structure of those two types of final order. That's the first point. The second point is that within her oral evidence, the social worker told the judge that the local authority would work with and accommodate any order and any placement decision made by the court. The social worker indicated that that might require further meetings to take place, but the local authority, through the social worker, did not push back against the idea of there being a care order at home. Your lordship will be familiar with some cases in which there's a standoff, as it's sometimes described, between the court and a local authority, the court saying that it would like a child to remain in a placement under a particular order, the local authority saying no. The court has the power to invite the local authority in those circumstances to think again, albeit not to impose upon the local authority ultimately a care plan with which it doesn't agree. So the social worker's concession in oral evidence that were a care order to be made by Judge Bugeja, with the court approving the child's placement at home, it would do that. That's an important concession to make. And one way I suggest that one might deal with this case now on appeal would be to, if it succeeds, would be to give the local authority, say, until Wednesday of next week or even Friday of next week, to indicate whether, if a care order were made by this court approving a placement at home. Now just start that again. If this court determined that the child should stay at home, whether the local authority would accept a care order on that basis. If the local authority were to say that it did, then it would be open to this court to make a care order, knowing that the placement was therefore secured. If the local authority were to confirm, contrary to the social worker's evidence, that the only order by which the child could remain at home was a public law supervision order coupled with a child arrangements order, then this court would not be able to achieve that placement under a care order, and we would say that the only way of achieving finality would be a supervision order. I invite the court, therefore, to think about those options that might achieve finality in, the Guardian says, a permissible way, and that does not require the court to engage in any impermissible evaluation of fresh evidence. These proceedings have been extremely long running. I appreciate that the child is in placement. We appreciate that there has been no change to the status quo, but plainly there is still a pressing need for final decisions to be made. Mr.
difficult with me, one of the difficulties with that approach might be that in this particular case, the evidence before the judge crystallised in or about September, didn't it? I think that was the last day on which any evidence was given. There was obviously one or two statements that came in after that. That's really it. And we're now at the end of the first week of February, so quite a way on. Does this court really make effectively welfare determination on an outcome of an appeal where there's a gap in knowledge about what might or might not have been happening in the last 4 months?
Well, my lord, I would suggest yes on the facts of this case, purely because nobody has even hinted at the emergence of any new evidence that might take the welfare evaluation one way or the other. I'm not suggesting that that would necessarily have required a Aladdin Marshall application to admit fresh evidence, but conspicuously absent from anybody's submissions has been the suggestion that the fundamental ground here has shifted. So in short, we challenge what fresh evidence would achieve in those circumstances where, in reality, the status quo has just subsisted. I move on, if I may, really by way of bullet points, to deal with the inadequacies we say in the judgment in relation to the court's approach to the risk of harm in the mother's care. Our fundamental submission, my lord, is that the judge focused almost exclusively on risk rather than how that risk might be mitigated. I've cited, I don't ask the court to turn to it now, but I've cited in my skeleton the Supreme Court case of Re S.B., which deals with the court's approach to future harm. It's clear from that authority that a local authority does not need to establish to the civil standard future harm. Future harm need not be probable. It's sufficient for there to be a real possibility that cannot sensibly be ignored. However, any assessment of future risk must depend on proven facts, facts found proven to the civil standard. In this case, as your lordships have heard, there is no question at all that the father continued to pose a risk to the child, but that risk depended substantially, if not exclusively, on the mother's ability to protect her. And applying, therefore, the Re S.B. discipline, the court was required to make solid findings rooted in the evidence that might help it to understand future risk and make findings about future risk. And that also required the court to determine what services might be and might not be available in order to reduce the risk. In those respects, we say the judgment was deficient. A word, if I may, about the mother's ability to protect this child. Yes, she had emotionally maintained her relationship with the father until her Damascene moment in the witness box, but she had also, as Mr. Nuvoloni has outlined, adhered to the safety plan to the letter, and there is no evidential dispute whatsoever about that. The mother's ambivalence about reuniting with the father up to her Damascene moment was only the possibility of reuniting with him if that could be agreed. She had never suggested at any stage that she would resume their relationship regardless. She had never, as some parents do, she had never suggested that she would run the risk of breach, and there was no evidence to support that. The safety plan had been an effective interim deterrent, and in our submission, the judge does not identify the basis for concluding that the mother would breach it in the longer term. by way of a side argument in relation to the question of risk, which hasn't necessarily been aired today thus far, and we put this in our skeleton, there was a passage in Dr. Garrett's oral evidence, and this is at paragraph 16 of our skeleton, core bundle B28, electronic 44. There was a passage in Dr. Garrett's oral evidence when she said, 4 lines into that quotation of paragraph 16, the concern I would have is not so much regarding the father, but the ongoing vulnerabilities the mother is having. If it emerges that the father has been making contact with other women, she may not want to pursue him, but with her ongoing vulnerabilities untreated, I would be concerned about her forming relationships with other individuals posing risks to her and her daughter. There was no evidential basis, we say, for finding future harm based on the risk from unidentified, risky individuals who at present play no part at all in the mother's or the child's life. Now, that passage from Dr. Garrett's evidence finds its way in part into the judge's summary of findings. Core bundle E80, that part of the judgment where she summarises her core findings, she notes the mother is vulnerable to forming relationships with other individuals who may pose a risk to her and her daughter. But we say, my lord, it's interesting that the nuance of the expert's oral evidence is lost there, because what Dr. Garrett had said was that the concern is not so much the father, if the mother doesn't pursue him due to him making contact with other women, but her forming relationships with other individuals who pose risk to her and her daughter. So that slight and subtle shift of focus by the expert in the middle of the oral evidence towards the risk from unidentified individuals and away from the present risk posed by the father to the child was one that the judge has, we say, misevaluated in her judgment, because she seems to simply conclude that the risk to the child in the mother's care would be enhanced by these other unnamed individuals being involved in the child's life. So the judge concludes in the passage that you've been taken to already at paragraph 482 of the judgment that the mother's instinctive response to protect the child is compromised. In our submission, that bold conclusion, which is obviously critical to the integrity of the judgment taken as a whole, is unsustainable. I then ask your lordships, please, to look at paragraph 176 of the judgment, which is at core bundle E27, electronic 116, in which the judge highlights in bold a key passage, she says, in Dr. Garrett's evidence. Paragraph 176, my lord. E27, 116. I would suggest that given the mother's views, in particular regarding her attachment to the father and her resistance to undertaking psychological therapy, once scrutiny by Children's Services is removed, it would be highly likely that she would resume a relationship with the father, and hence her protectiveness would be compromised should the child remain in her care. This would necessitate further involvement of Children's Services in the child's life. Just invite the court to reflect on the caveats inherent within that highlighted passage. Insofar as this is a distillation of Dr. Garrett's view about risk, it requires the mother to maintain her resistance to undertaking psychological therapy. And that position, of course, had changed by the conclusion of the case. Second, and curiously, we say, it requires Children's Services scrutiny to be removed. Nobody at all in the case was suggesting that that would be an appropriate outcome if the child stayed at home. And the third caveat is that the passage assumes that the mother would contravene any safety plan by resuming a relationship with the father in such a way as to bring him, in an unauthorised way, into contact with the child. So there are three key fundamental caveats there, none of which, in our view, resound in the actual evidence. The judge approached that passage, or seemed to approach that passage, in black and white terms. There didn't seem to be, again, looking at the judgment as a whole, any nuanced analysis by the judge of what services the local authority might bring to bear on the placement. Seems to be no attempt by the judge to push back against Dr. Garrett's report there and to say it's not a question of Children's Services scrutiny being removed. It's a question as to the impact a final order would have on the continuation of services going forward. And if the judge had looked, as we say, I'll develop this point in a moment, more carefully at the different protective services that could have been brought to bear on the placement either under a care order or a supervision order, we submit that the judge would have been better able to rationalise the risk. Our next point, my lord, is that the judgment denies the mother the opportunity to demonstrate insight going forward. There are positive observations about the work she had undertaken with an organisation called New Start. No evidence of minimisation. We refer to our skeleton, paragraph 14. The judgment did not allow for the momentum that might have been initiated by the Damascene moment in the witness box. And the judgment did not allow for the possibility that the mother's previous rejection of therapy might shift, either as a result of her new insight or because of the early application of therapy itself. We would see no reason why therapy couldn't be brought to bear in the first instance on the mother's previous resistance in order to provide a more fertile ground for it continuing in the longer term. One then has, at E73 of the judgment, paragraph 482, the closing, penultimate sentence at paragraph 482, E73, electronic 162. This is the point about the epiphany. I do not consider that her recent epiphany in the face of ambiguous intent to separate in the past can be relied upon until such time as it is tested and maintained. Our submission, my lord, is that going forwards, because of the 5-year point, there was time enough to test out the epiphany, to test out whether it was maintained. And accordingly, the judge formed too early and too dogmatic conclusions about risk that would only critically eventuate at a point in the future. And just to remind your lordships that Dr. Garrett's evidence was that the mother required 25 sessions over a period of 12 to 18 months. Dr. Garrett accepted that the child could remain in the mother's care whilst the work was undertaken. The judge recorded paragraph 203, many providers might be able to start quickly, and the initial session might give an indication of the mother's motivation. And the 5-year point, of course, has its foundation in Dr. Garrett's own evidence, as reflected in the judgment of E29. On that area of our submissions, I close with reference to paragraph 493 of the judgment at E77, electronic 166. Paragraph 493. I do not see, says the judge, how the sharing of parental responsibility would mitigate the risks. I considered the only way in which the risks to the child would be mitigated if she remains in her mother's care are if the following occur. The mother must remain separated emotionally. The mother must be able to demonstrate insight into the father's offending history. And the mother must engage and choose to engage in the recommendations set out by Dr. Garrett. So the judge herself sets out starkly there the preconditions, in her eyes, for the child remaining in her mother's care. In our submission, the judge did not have adverse conclusive answers to any of those 3 issues, because the answers would only become apparent in the period between the end of the final hearing and the conclusion of the intervention and therapy that the mother would undertake, and therefore, given Dr. Garrett's timescales for that, would conclude at a point well before the key risks materialise. So in short, and in lay terms, there was time in hand for that question, or those questions, to be answered properly. My Lord, I turn to the second core submission that we made. And in fact, this will be our final submission. And it relates to how the question of risk assessment affects the judge's analysis of the different welfare options in the case. In our submission, a care order at home was plainly a realistic placement option for the court to consider. The sharing of parental responsibility with the state in those circumstances was an obvious foil to the risks posed by the father and the risk that the mother might for the first time breach a long-term safety plan. Yet, the final social work evidence in statement form did not refer to the child's placement at home under a care order as a realistic option. Indeed, it's worth noting in passing that supplemental bundle C36, electronic 92, which is the part of the social worker's final evidence in which she sets out the different placement options, not only doesn't refer to a care order at home, but in the context of a supervision order, mid-page, it states supervision order with the mother and the father, as if there's some intended conjunctive placement proposed, when that, of course, has not been on the table at any stage. But I return to the question of a care order at home, which was, of course, as you know, the guardian's final position. As I think my Lord Mr. Justice Cobb has indicated in earlier argument, the analysis by the judge of the key case, Reed JW, that relates to the appropriateness of a care order at home, a relatively recent authority that's in the authorities bundle. The judge's analysis of that was superficial. When one turns to the judgment at paragraph 486, E75 core bundle, electronic 164, paragraph 486, one sees the judge's citation of Re JW, but then there follows an analysis by the judge as to whether the facts of this present case fit with the facts of Re JW, as if to marginalise the importance of that authority if the facts don't coincide, when of course the judge should have been applying herself to the question of whether or not exceptionality was made out such that this child should have been placed in the long term with the mother under a full care order. The judge should have asked herself what additional benefits would flow from the making of a care order and shared parental responsibility in respect of this child. And we say, had she done that, she would have formed the obvious conclusion that this was an exceptional case where a care order at home was warranted. At the IRH, the judge had herself described this case as one of, quote, extreme risk, thus bearing out our submission in relation to exceptionality. The next point, my lord, is that at paragraph 176 of the judgment, within that bold passage that I referred to earlier on, I'll just come back to this point about the scrutiny of children's services being removed. The emphasis by the judge should have been on maintaining local authority scrutiny and understanding how that informed the eventual outcome. The judge had at her disposal the ability to require the local authority to engage with any views expressed by the court about the care plan. The judge had the ability to require the local authority to create a bespoke care plan with unannounced visits at whatever frequency the social work team thought was necessary to protect the child. The judge was not limited to the resources set out by the local authority in the shadow care plan, in the sense that, as I say, the court could have required the local authority to think again. And the judge should also have taken into account that a care order, for example, unlike a supervision order, is not limited in its duration. A care order will last for the child's minority. A supervision order will last for 1 year, extendable up to 3 years. So we say that there were obvious reasons why this was a case in which a care order might be made in order to maintain local authority scrutiny in the longer term through and beyond the 5-year mark, at which point the risk most acutely crystallised. When one looks at the judgment at paragraph 484, of E73, electronic 162, there is a passage in which it's on the following page, still within paragraph 484, but on E74, there's a passage at the top of the page in which the judge considers what interim measures have been in place that might be lost at the conclusion of the proceedings. 4 lines in, the mother has had the benefit of an exclusion order. She's had the benefit of solicitors who will have given her robust and sound advice. She's had the benefit of being within proceedings wherein there was ongoing monitoring, supervision and surveillance. Now, of course, the benefit of a solicitor within proceedings would fall away at the conclusion of proceedings, but all the other points in relation to an exclusion order or long-term local authority monitoring, supervision and surveillance could be applied in the longer term. And I jump back to paragraph 201 of the judgment. On page E31. In which the judge records at the end of that paragraph Dr. Garrett's reply that the mother knows that she has to abide by the framework at present because she knows what the consequences would be if she did not. She said if there was any leeway or if any of that strictness would be removed, her opinion is that the mother would deviate from that. First of all, there was no evidential basis on which the judge might accept Dr. Garrett's opinion on that front. And secondly, as I say, at the risk of repetition, there was no engagement by the judge with the services, the monitoring services and the protective services that the local authority might apply in order to militate against that risk. And so when the judge comes to apply the discipline set out in the judgment of Lord Justice Peter Jackson in Re F at 484, and I am sorry to jump about, that paragraph deals squarely with that authority, and the judge sets out, as she must, the type of harm that might arise, the likelihood of it arising, the consequences for the child, but then what steps could be taken to reduce the likelihood of harm arising or to mitigate the effects on the child if it did. The judge's conclusion is too bland and unsupported by the evidence and discloses, we say, a fundamentally insufficient analysis of the support services and the orders available to the court to militate against risk, because the judge simply says this: I do not consider that there are any steps that could be taken at this time to mitigate the risks to the child in her mother's care. So the judgment just does not engage with whether or not the shadow care plan would suffice or the ways in which there might be amendments to the shadow care plan in order to maximise the security and safety of the placement. My Lord, I turn finally and briefly to this question of the grandparents and the evidence that emerged about a parallel minimisation of risk as between the grandparents and the mother, at least up to the point the mother gave her oral evidence when, as this court knows, she indicated that she, for the first time, was moving on. In the judgment at paragraph 163, on page E24, 6 lines into that paragraph, Dr. Garrett considered that the father's parents appeared to minimise his offending. They themselves regarded him as posing no risk of reoffending, which she considered was important when considering the potential impact for the mother to be able to appraise the risk posed by the father in circumstances where his parents were one of the few sources of support available. We make this point in our written skeleton, that the judge focuses in that passage entirely on the way the risks inherent in a placement with the grandparents might reflect on the mother, rather than, as we say the judge should, reflecting on what that said about the risks in the grandparents' care comparative to the mother. Yes, the guardian did ultimately say, as reflected in the judgment, that the grandparents were a lesser risk as compared with the mother, but that was not the question that should have informed the judge's ultimate decision. The question was whether the placement with the mother was too risky. We say that the judge should have undertaken a more coherent analysis of the possible risks in a placement with the grandparents if the judge was going to land at the mother's door, if I can put it that way, the assertion of minimisation and association with the father. So the court did not proceed, we say, on an even-handed basis on that front. Just to clear up the factual point, I think the Lordships know this, that there was no formal application to the judge for the grandparents to be heard. And I say that in two senses. There was certainly no formal written application, but you would never expect that in family proceedings. But nor was there an oral application made by my junior for the grandparents to give evidence. It was mooted by him as something the judge might want to do on the very first day of the final hearing, the 1st of August. And the judge indicated that that was not necessary. In my submission, there was no further duty on my junior to raise that as a necessity or to press the point, given the judge's indication in response to what he had said. And in those circumstances, my lord, we say that the judge did err in proceeding without hearing directly from the two people in whose care ultimately the court decided the child should be placed. My lord, may I turn my back?
Yes.
My lord, can I assist any further?
No, thank you very much.
Thank you.
My lords, would you mind if I just raise one matter in relation
Please
to
do
the very
go
first
ahead.
point that was being made on behalf of the child, and it's also dealt with, and I should have picked up on it earlier, so I apologise. It's dealt with in the skeleton argument on behalf of the children at B32, and the suggestion that the social worker conceded in her evidence that the local authority would accept a care order. I think that may be taking the social worker's ability to do that a bit far, because if we take a look in the judgment at E35, paragraph 232, and E77, paragraph 494, the impression there is that the social worker was indicating that it would be a matter that would have to be considered by management, and then we see in the later comment that the judge has indicated that she saw no point in sending it back to be reconsidered because effectively that had been done during the course of the process. So I'm not sure that it was as clear cut as 100% acceptance that the local authority would accept. The social worker does not have the power to make that decision under the placement with parent regulations that I referred to at an earlier point when I was on my feet. So I just wanted to urge a little caution as to how that was received.
Thank you. Any reply?
Nothing I need to add to anything.
Very good. Well, we'll rise and consider to do. We are very grateful for all the submissions that we have received this afternoon. This is clearly a case of some importance and difficulty, and in those circumstances, I'm afraid we are going to reserve our judgments. We will get them to you as soon as possible, but we think some reflection on the submissions is best in all the circumstances. As I'm sure everybody in court appreciates, but for the avoidance of doubt, the procedure in these circumstances is that drafts of the judgments will be circulated in due course to counsel and solicitors whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors, and if possible agree a draft order so far as possible. And if that process of agreeing a draft order is not possible, file brief written submissions so that the court can finalise an order at the same time as hand down. Once all of that has been undertaken, the final version of the judgment will be handed down remotely with no need for further attendance. Circulation of the drafts to the parties or any other person for the purposes identified in the Counsel for General of Wales case will be the responsibility of solicitors. Any such circulation is for those purposes only, and any other publication, I'm sure you will appreciate, may be a contempt of court. I'm sorry to repeat that warning, with which I'm sure all the professionals are well acquainted, but nevertheless it's as well to do that. So thank you again for your assistance. Could I just remind you that in the course of the hearing, promises were made for which we were grateful, that further documents would be supplied as and when you managed to locate them, specifically the interim orders and arrangements to the extent that they're not in the bundles already. And secondly, the one page of the setting out the details of the convictions.
I think also there was the email that was sent from the social worker after the conversation.
Thank you for the reminder. Yes, that too will be of assistance. Thank you very much.
Missing authority.
Yes.
Well, that you needn't worry about, because that we've tracked out also. Thank you very much.
Because we didn't find it.
Yeah,
Because you haven't yet to check it, so that's what we think.
my recollection is that it was in connection with the